Hi, my name is Melissa Fish, corporate and mergers and acquisition attorney and owner of Fish Legal Counsel. Today I'm going to talk to you guys about the anatomy of a deal, what it looks like to close a deal from start to finish. So the first thing we start with is a term sheet or letter of intent. This is basically a non-binding document that lays out all of the principal terms of the agreement, but the parties are not obligated to follow through on these terms. This is all things that the parties come up with before due diligence has occurred, so a lot of things can change. For example, I was just working with a client who had set a purchase price for a business of 1.4 million. Upon entering into due diligence, they realized that the revenue of the company was not what they expected. So we decided to structure the purchase price with an earnout. This means that the seller gets a deposit towards the purchase price, and the rest of that purchase price is paid over time based on the revenue of the business. Now, this did cause a moment of concern for the seller, who understood that the letter of intent said 1.4 million, and therefore that's what he was going to get. But the truth is, a letter of intent is often just a starting point for the parties to begin negotiation until they discover more about the nature of the business. Now, once you have the letter of intent set, it's good to understand that there are some binding provisions of it. So for example, confidentiality, keeping information safe that the seller is providing to the buyer. Exclusivity. This is a great protection for the buyer, which gives them the exclusive right to be in negotiation and talks with the seller for a certain period of time. That way the seller is not talking to other parties while the buyer is spending time and effort doing their due diligence. And finally, choice of law or governing law, basically saying that this contract or any disputes are going to be governed by the laws of the state of California, for example, which is where I practice. Then you get into the definitive agreement, the purchase agreement. This is where we begin to really get solid on the structure of the deal. So the purchase agreement is going to be the final terms. These are all binding. We're going to figure out exactly what the purchase price is, how the structure is going to work. We're also going to figure out whether it's going to be an asset or a stock purchase. So another example, I had a client who was looking to purchase an online event platform. Upon doing due diligence, we realized that the entity was actually suspended for lack of paying franchise taxes to the state. So the initial intent of doing this as a stock purchase was not going to work. That's because in stock purchases, all the assets and the liabilities of the business transfer as a matter of law to the buyer. My client did not want to take on the liability of past state taxes. So we changed the structure to be an asset purchase in which the client picks each individual asset that they're going to buy. In this case, it was a brand, it was a website, it was a domain, it was client lists, other assets that make the business valuable while explicitly excluding the liabilities that they did not want to take on. Once you've got the purchase agreement completed, you also need ancillary agreements. I draft these for my clients as well. What these are additional agreements that are needed to effectuate the transfer. So for example, in an asset purchase, if there's real property, you need a bill of sale. If there are contracts that need to be transferred, you need assignment and assumptions. Sometimes there are third-party consents that need to be gotten. So I help my clients draft all of these agreements to ensure that they're actually purchasing the business as they intend, as well as any corporate consents that may be needed in order to authorize the transaction. Once you have all of these down, you have the purchase agreement, it's time to sign and close the deal. And that is the anatomy of an acquisition.